Hi everyone, this is the final part of the video series on the government's aim to ban fire and rehire provisions within contracts of employment. We spoke in the last video about this being largely limited to pay, hours and holidays, the concept of restricted variation and the lack of ability in employers to offer to dismiss and re-engage employees on more detrimental terms or to replace them with other employees or indeed non-employees. What we also touched on was the fact that there is an exception to this rule. So these variations or fire and rehire provisions could be lawful where an employer faces financial difficulties. So if the reason for the restricted variations, so variations to pay hours or holidays, for example, were to eliminate, prevent, or significantly reduce or mitigate the effect of financial difficulties, which were likely to affect the ability to carry on the business, and we couldn't reasonably have avoided making those variations, that can act as a defence to any automatic unfair dismissal claim. So we're not going to focus on the local authority definition, which is slightly different. We're just talking about private sector employers and applying the financial difficulties exception. The government's intention, clearly by virtue of the drafting, is to make this apply in very limited circumstances. So this can't be simply about reducing or mitigating any financial difficulties. The impact must be significant, or we must be eliminating those difficulties or preventing them altogether. So we will essentially have to show that the business was at risk, or at the time, or in the immediate future, would be at risk of failing. So we can't simply say that we're doing this to avoid problems which may happen further down the line, and we can't speculate without any particular evidence. So the tribunal will need to make a decision as to whether the business could or could not have reasonably avoided making these changes. As you can see, that's going to be quite a high threshold to overcome, and evidentially, it's probably going to mean disclosing what could be a lot of sensitive information about the future of the business. We have to essentially show that imposing changes to things like pay, hours, and holidays is crucial to the survival of the business, and again, not simply to mitigate any challenges the business might face going forwards. Does that mean we might have to instruct financial or restructuring experts to give evidence? This could make tribunal hearings much more complex. And ultimately, I think this defence will be used quite sparingly and potentially only in cases of desperation where a business can genuinely show that they might be facing financial ruin otherwise. Perhaps there might be a triggering event such as the loss of a major customer where the business can genuinely show on a cash flow or profitability projection that if they maintain the same level of cost, they would face financial catastrophe. But in those circumstances, a business would probably turn to redundancies in any event, so they wouldn't be rehiring any employees in the circumstances. Now, if that is satisfied, the tribunal then actually has another test to undertake, and this takes us back to the current legal position. So it's one thing overcoming the hurdle of showing that the business was in genuine financial difficulty, but the tribunal then has a task of identifying whether or not, on ordinary fairness principles, the employer took an acceptable approach. And the legislation states that the tribunal should take into account any consultation about varying the employee's contract, if there is a union or standing body of representatives, the extent to which they've been consulted with, anything offered in return for agreeing to the variations, such as providing certain other benefits in return for giving up others, and any other matters that are specified by the regulations. So in summary, if a business is wanting to amend pay, hours or holidays, any terms relating to that, and has extreme financial difficulties, evidence is absolutely going to be required in order to justify its decisions, and then a fair consultation exercise will need to be undertaken, just as we recommend in current circumstances. So that concludes the video series on fire and rehire provisions. No doubt some of this advice will be amended as the consultation gathers pace and the final version of the the Act is prepared following that consultation. In the meantime, if you do need any further assistance on this or anything relating to employment law generally, please do get in touch. Visit the website chadwicklawrence.co.uk or email employmenthub@chadlaw.co.uk. Thank you.